Let's bring you some election petition updates. Joining us for a conversation ahead of this crucial court hearing today is Abraham Amaliba. He is legal director for the NDC, and he's usually in courts, sitting in on these processes. We also have Dr. Poku Edusei, who is a member of the MPP communications team, joining us. There you are. Good morning to you. Both of you, Ms. Amaliba, if you can hear me. Hello, Ms. Amaliba. Hello, gentlemen.
Yes, I can hear you.
Okay, Ms. Amaliba, I can hear you as well. Thank you so much for your time. So you have a review that would happen, in court today. It's interesting that the review is not about the recent decision, but this is an earlier decision where the court had ruled that they could not compel the Electoral Commission to put its witness, Jean Mensah, into the witness box. There's also the stay of proceedings. So can you first of all tell us if that will also be heard, that application?
Yes, the court on the 11th of February ruled that the Mensah is not compelled to enter the witness box. Agreed by that ruling, we decided to apply for a review of that. But don't also forget that the Supreme Court has ordered that parties in this case should file their closing address. If you file your closing addresses, it means that the case has come to an end. You are now just waiting for the judge. And so this day of proceedings is to arrest that situation and then allow the Supreme Court to still over application for it before the closing addresses are filed. So the two applications are intended to achieve different purposes. Stay of proceedings is to halt the process while the application for review to ask the Supreme Court that they want them to issue that. 7th February.
Ms. Amaliba, sorry I have to interrupt, but you have to reposition yourself for me so we can hear you clearer. There are some breaks in this connection, so please reposition yourself. In the meantime, Dr. Poku Edusei, good morning to you if you can hear me.
Good morning, Mama B.
Okay,
good morning.
Great. So has your side complied with the court order in terms of the deadline yesterday with the written addresses?
Yes, we have. And yesterday in the evening, the second respondent filed his written submissions or closing address as ordered by the Supreme Court of Ghana. It's not the first time that the second respondent's lawyers have been diligent in complying with orders of the court. And it came to the fore when the Supreme Court ordered a while ago, that's about a month ago.
Okay, unfortunately, I think we're having connectivity issues. Dr. Poku Edusei, we lost you quite a... Hello?
Okay. Yes, I can hear you now.
Okay, so we lost you there briefly, but you can go on.
Yeah. So about a month ago, when it got to the stage of filing witness statements, the Supreme Court gave a similar order, and we duly complied with it and filed that statement. For the petitioner, they did not at that point comply with the orders of the Supreme Court. And we realized that it didn't serve the ends of justice in terms of fairness under the adversarial.
We have to apologize for the intermittent breaks there that we're experiencing with the connection. Yes, it is okay. Yes.
Yeah, so we realized that when the court was rising, I think on Tuesday, our lawyer, lead lawyer, Mr. Gotoampao, gave indications that we have a precedent a history of the petitioner not complying with orders of the court. So they will wait till the respondents file their processes, and then they will try to identify whether a lacuna or any opening for them to fill it in. So we were also worried that if you go ahead to file, they may not file. And for more indications, they have not filed because they think they have filed an application for review and they have filed an application for stay of proceedings. But the decisions of the Supreme Court are quite straightforward.
So let me, Dr. Pokodu say, let me just quickly check with Mr. Amalba. Mr. Amalba, if you can hear me, can you?
Yes, I can hear you.
Okay, great. Did you meet the deadline the court sets for the written addresses yesterday?
No, it's not possible to do that when we are filing a stay of proceedings. Then we are also filing a petition for it.
But are you mind? Yes, Mr. Amalba.
I've indicated in my earlier submission that once you file those ones, written addresses, the matter comes to an end. Once you take a new step, the matter comes to an end. And so we have a grievance. We are not in the same boat with them. They shouldn't lament with them. They are having rulings in their favor.
But so Mr. Amalba, I remember the last time you did not follow the court's order, the Chief Justice was quite upset.
Yes, this time it's quite different. This time it's at the tail end. Once it's at the tail end. So once you file the proof address, the matter ends.
So you don't interpret this as not following the court's orders?
This is not disobeying the court order. This is a very, very substantive matter which needs to be addressed. If we go ahead and file the proof address, the matter comes to an end. What then becomes political issue? It comes in the air. They are not in the same boat with them. They have rulings in their favor. You think people were also in their who were filing this? We are agreed. We are mourning. We are jubilating.
Mr. Amalba, is this normal practice, though?
Yeah, it's normal practice, yes. That if you are agreed, as we are agreed, to file an application for review in the Supreme Court. In the lower court, we file for an appeal. You file an appeal against the ruling of the lower court. So, yes, it's known to our law.
But this is not an appeal, is it? This is a review.
No, you don't understand. I'm just trying to clarity of reason. I'm saying that these applications that we are engaged in or we are filing are not unknown. They are known to our law. It's not something out of the blue. And I'm saying that it is more or less asking the Supreme Court to review or an appeal against their own. But I'm not saying that it's an appeal. Just to bring it home for people to understand that if this were a lower court, would have been appealing against it. But because the Supreme Court, we are going for a review. So we are not in the same boat with them. They shouldn't carry us along.
Okay.
People, when they are move between what we are doing.
Okay. Thanks for the clarity. Just stay with me a little longer. I know you have to go to court. You're probably on your way there. But Dr. Pokodu say what Mr. Amalba says is clear, isn't it? I mean, if this is normal practice, once you file your written address, it means that the matter has come to an end.
It is not a normal practice in that when you file the processes in court, and the intent of it is basically to stultify the further progress of a pending action. You don't think that an order which has been granted earlier in time will be arrested because of the processes you have filed. There's a decision of the Supreme Court in next party, Khalib, which was given somewhere in 2015, that processes can be filed. You can file applications for whatever, interlocutory injunctions, whether for stay of proceedings, but it doesn't mean that when there's an order, you sit in your bias office or corner and interpret the order in the way that you want it to be. You know, even in the unlikely event of they succeeding in the review application, they will be permitted, or the rules permit them to file supplementary written address when you succeed in your application. So they will not be able to interpret the order because they have filed the process on their own. In that case, you are disobeying the orders of the court. And the court were explicit in that when they failed to comply with the witness statement filing. And they did it. We have learned from that they did it in that way, so that we will not be able to, or they will be able to fill in gaps that had been left in their case. But I think we are almost at the throes of this case, and these processes will not be able to save them.
Mr. Malba, how do you react to what Dr. Poku-Edusei just said? You could have still gone ahead, obey the court's order, and then if you have additions, they could allow you to do that.
Don't see how that happens. That you have a review application, which review application would impact on the case. Don't you think that if the Supreme Court finally agrees to that and sees that the Mensa to come into the witness box, that's huge. That is a huge issue. That is very huge for this case. And you are saying that we should file our closing addresses and then come with supplementary, and that if we did that, it would now come with a supplementary to no. Clearly, the thing that the men start taking the witness box at the heart of this case. And that is why we are not even concerned. Have you noticed that we are not even concerned with the second respondent saying that he will not take the witness box? Both of them said they won't take the witness box, but we are not even concerned. After the second respondent, you can decide to go and you don't care. So we think that such a huge matter of having the EC commissioner in the witness box, it's not just a minor issue that we say that go ahead, file your closing address. Then how do we factor in comments, testimonies, and all those things into our witnesses, into our closing address? I think that this is a huge matter. In fact, the main reason why we went to court was to get there into the witness box, to tell us how figures, how this both staff kept changing and changed up 5 times. That's what the people of Ghana want. It has never happened in any part of the world where an electoral commissioner has not been able to provide us with that. And I think that getting her into the witness box will quick out.
So, Mr. Malba, how do you intend explaining this matter to the courts today?
We are going to the court today. In fact, before the case adjourned the last time we went to court, we had indicated to the court that we have filed all this process. So it's not like the court is going to hear them today for the first time that we have filed a stay and then we have filed an application. Fortunately for us, for this time, lead counsel, Chatikata, had informed the court earlier on. And indeed, you heard the Chief Justice make the point that, have you been given a date? In any case, we are coming back on Thursday. And fortunately for us, the date was fixed for our
Okay, Mr. Malba, you think that this is an excuse that the court will agree with you on?
So let's wait. The difference I want to draw in this one is that it's not like the earlier one where the court was not seized with that information. Just stated. This information, this time, at the last agenda, before hearing was adjourned, this council had made it clearly, articulated clearly.
But I also do remember, Mr. Malba, that the Chief Justice asked if he had a date, and at the time he didn't have a date.
Exactly.
So formally, nothing was.
So that's why
was on notice.
That's why I'm saying that if we hadn't told the court that this is what we are about to do, the Chief Justice would be asking, have you been given a date? So I'm just trying to tell you that this is not one of the things that would take the court unaware. They are aware of this.
Okay, Dr. Poku-Edusei, this is certainly a strategy that you would have also, used if you were the petitioner in this case.
Well, we don't believe in ambushing our opponents in that kind of way.
Well, how is that ambushing? They did say in open courts. No, I was just saying, how is that ambushing? Because you knew what they were going to do next.
Well, but the order was also prior in time, and you can comply with it and file whatever processes you want to file, right? We have learned from the witness statement of Mr. Rojo Metonunu that the original document had 16 paragraphs. It ended up being 32 paragraphs. From paragraph 17 to paragraph 32, they were basically filling in the gaps. In fact, the manholes left in by Mr. Pesa White when he mounted the witness box, because he never had any personal engagement with the woman. And therefore, his issue of so-called instructions turned out to be a ruse. So it changed from instructions being information or informed by the person who was actually in front of the woman a couple of times. So we think that it's a strategy to fill in, but this will not save them. At this point, when you go to court, the review is for today. And the basis or the justifications for determining matters of review are clear-cut in the law. Are there new evidence they have found, which they couldn't have used reasonable means to find? Even if there is new evidence and you could have found out by being diligent, it means that you will not be able to succeed. And then the second one is whether there are exceptional circumstances in terms of, let's say, a law which is contrary to the decision of the Supreme Court. Without that kind of clear justifications and basis, there's no way you can succeed in review applications.
All right, gentlemen, I guess I have to let you go. Mr. Amaliba, we wish you the best in court today as you still continue with this battle.
Yes.
Okay, great. Dr. Poko, hello, Mr. Amaliba.
I'm just saying that we shall soldier on and get the bottom of it.
Okay, great. Well, we will be here watching and following procedures. Dr. Poko to say, I am grateful that you could join us.
But soldiering on, it comes with strategy in the war front. Otherwise, you lose all your skilled workers at the forefront.
Wow. We wait to see what happens. Thank you very much for your time as well. We will go back to the Supreme Court and look at what the situation is ahead of what will happen today. But it will be very important to hear what the Chief Justice would say. Would it be as we witnessed the last time when the petitioner failed to comply with an order of the court? We will touch base with our colleague Kweku Asante, who would be telling us what the mood is in court ahead of the sitting. We're also roving today on the back of an issue that came up at the vetting of ministers designate yesterday in Parliament. Mr. Mahama Yariga, the Boko Central Member of Parliament, raised an important issue. We know that by law, there is a compulsory retirement age of 60. In some exceptional instances, contracts could be extended for another 5 years. But he is advocating for an extension of that compulsory retirement age from 60 to 65. As the employment minister designate appeared before the committee, we will tell you what others make of this view, especially civil servants. So stay with us here on the AM show. All these coming up.